they have gone against a warrant. From what the OSP is telling us, it doesn't appear that the OSP has actually gone to court for a warrant for him in this year. So what do you think is happening?
That was one of my challenges or my queries, curiosity with the application. Because if you read the application that was filed by the lawyers for Mr. Bissue was based on an originating motion that they had also filed in the same court asking for certain reliefs. Now, the reliefs that they were seeking from the substantive relief in the originating motion for their human rights breach were in respect of a purported arrest warrant. And so, remember, previously, the lawyers for Mr. Bissue had issued a writ of summons challenging the OSP's right to even investigate Mr. Bissue. That is one action. Then after the so-called arrest warrant came into public domain, the same lawyers issued another new action by means of an originating motion under Order 67 of the CI court rules to say that that arrest warrant was obtained in breach of the fundamental human rights of Mr. Charles Bissue. So the court should eventually set aside that arrest warrant. It was when they filed this originating motion that they filed the application ex parte. Now, everything about the originating motion and the application ex parte is hinged on the so-called arrest warrant. And so one would have thought...
They call it purported
arrest warrant. Now, one would have thought, as is the practice, that if you seek to invoke the jurisdiction of a court to challenge a process, you must adduce evidence of the existence of that process before the court. Because something you and I know that judges do not make orders in a vacuum. So, for instance, I cannot go to court to say that Samson is threatening to slap me, and so he should be restrained, unless I have provided prima facie evidence of that attempted slap to the court. Otherwise, the court would be an exercise in futility. Because
what you mean, simply put, is that in this case, the court should have seen the actual...
I think arrest warrant, yes. Because the grant or otherwise for an application for injunction, one of the grounds, is whether there is a real question of fact or law to be determined between the parties.
So let's make progress. What happens from here? You said it lasts for 10 days.
For 10 days.
So he cannot, if there is, that is if, if there is any such arrest warrant, it means the special prosecutor cannot execute it.
Yes.
By arresting Charles Bissue.
Based on that warrant.
Within 10 days from that day.
Based on that warrant.
Explain that. What do you mean?
You know, the application filed and the order from the court is restraining the special prosecutor from arresting Mr. Bissue based on that purported arrest warrant. The application and the order did not seek to restrain the OSP from arresting Mr. Charles Bissue. That is not why they went to court. No, if you read the affidavit and the reliefs they were seeking, they are not seeking, we hereby pray the court to restrain the OSP from arresting Mr. Charles Bissue.
So that's why the OSP has issued a statement to say that it has power to arrest anybody without a warrant.
That is so, because it's clearly within the scope of their mandate that they can arrest you without a warrant, just like the police.
Are you saying the OSP can actually go ahead and arrest Charles Bissue?
From the evidence of the affidavit and the wording of the order, in my humble opinion, the OSP can arrest Mr. Charles Bissue if he sees him today, as long as the OSP does not say, I am arresting you pursuant to that arrest warrant.
A warrant.
Yes.
Which we do not know exists
on, because it wasn't exhibited to the application filed by Mr. Bissue's lawyers. And the OSP has also not made it public that indeed we went for an arrest warrant. We have not seen it. So as long as the OSP says, I'm arresting Mr. Bissue, but I'm not arresting you based on that warrant, I don't think the OSP would have breached or would be in contempt of the orders of this court, of the court.
Okay. Yeah. Well, they remain the orders, and until they have been set aside or vacated, it is lawful, and they must be complied with.
In terms of the order.
Interesting. Okay, so just seeking a little education for you, and I'm sure Bobby has helped us in that regard. Yes, there's another concern, that the OSP issues wanted, that somebody is wanted, and they publish it. people are saying this is alien. We are not used to that. What do you know?
Well, like you read in section 28, the OSP has all the powers of the police service in discharge of its mandate. The OSP, in fact, has the power to request a party to be present or provide documents or any other assistance. If that party who has been demanded or requested by the OSP to appear or provide documents or cooperate in any form does not do it, that in itself is an offense. And that is a very unique part of the work or the mandate of the OSP.
It may be that the OSP is getting into the public. Otherwise, if you go to EOCO's, their pages and things, they issue these,
yes. Even the police
wanted notices.
The police do that a lot. If you go to Central Police Station, you see notices. They have a notice board that if a complaint has been lodged, they are looking for somebody, the person has even jumped bail, they have a right to publish it, because you see, citizens have the right to also arrest persons. It's in the Criminal Procedure Code.
Right.
Every citizen, whether a security agent member or not, you have the right to arrest someone. So if you know that this person has been published as wanted, the OSP has told you we are looking for Mr. Kojo Mensah, and you see Mr. Kojo Mensah, as a citizen, you have the right under, I think, Section 8 of the Act 30, to arrest that person and take him to the office, either police or the OSP. And so it is not alien at all for the ASP to publish OSP to publish
notices.
Okay,
so the last thing I'll ask you about, then we move on to something else. I get a quick comment from my other guests and then we move on. It's being suggested, you've heard some criticism, that the OSP can be used by the government, particularly the Attorney General, who is a political person, because the OSP is not independent, and that the OSP prosecutes on the authority of the Attorney General. What does that mean?
You know, when the Act was in a bill form, that was one of the criticisms that some of us had of it.
Right.
But I cannot say that in the operation of the OSP's office, both Mr. Amidu and the current one, I have any inclination that they may be doing the bidding of because they've only operated under the MPP government. Because Mr. Hamidu, it was very clear that he said he was not happy with the corporation, so he left. Now, this current OSP, he has gone against certain government appointees. Mr. Bissue we are talking about is a known MPP person. Now, and this is where I think that I am a little bit happy with that provision, if the OSP completes a report and it says, the Attorney General says, do not prosecute, it will be published in his annual report. I expect it to be there. That I completed investigations.
That will suggest that the OSP goes to the Attorney General to ask, should I prosecute or should I not?
Yes.
Is that what the law says? In the preamble to the law, it says that it is to prosecute these corruption and corruption-related offenses on the authority of the Attorney General.
Yes.
Is this not usual in all other acts for these people or offices that must prosecute? Is it not the same in IOCO? Is it not the same for entities that are prosecuting? When they decide that I want to prosecute Bobby, must the OSP take the docket to the Attorney General and say, should I prosecute or should I not?
I do not think in practice and in operation that is how it works. However, the Attorney General, by this provision, can have a right to stop the prosecution. In the IOCO instance or the police instance, if the Attorney General's office writes a letter addressed to the police department and says that bring me this docket, it means you cannot take any step without it. And so the act was very also clear, like you said, on the authority of the attorney, because I think because of the wording of Article 88, that once the OSP will be prosecuting in the name of the Republic, and Article 88 says that it is only the Attorney General that can do that. It means any person that should do that should be riding on the authority of the Attorney General.
So in Ghana, by our Constitution in Article 88, specifically Article 88, is it 1?
Yes.
Article 88(4), no criminal prosecution can go on unless in the name of the Attorney General.
In the name of the Republic.
Okay.
But that power to prosecute has been vested in the Attorney General. And so you will now be doing it under the authority of the Attorney General. Okay. It doesn't mean that you should go to the Attorney General with every docket, but it also means that the Attorney General can stop you from doing the prosecution.
Right. So what then becomes the meaning of Section 4, subsection 1? It says, except as otherwise provided in the Constitution, the office is not subject to the direction or control of a person or an authority in the performance of the functions of the office. Then 2, subject to Clause 4 of Article 88 of the Constitution, the office shall, for the purposes of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offences. And finally, 3, subsection 2 shall not preclude Parliament in the public interest from requesting the office to investigate alleged or suspected cases of corruption and so on.
And so the powers or the government, as we mentioned, there are 3 arms of government. All the powers in Ghana is exercised through these 3 arms of government.
All right.
And so if you say subject to any other provision in the Constitution, one would think we have the executive arm, the parliament, and the judiciary. Of course, the judiciary is not relevant to this discussion. I believe that the 4.1 may have been targeted directly to the executive. That you do not have the executive having the right, because the OSP is nominated for
to
appointment.
Direct or control.
Yes, by the president.
Can't do that.
No.
They
However, no, the executive arm of government has no jurisdiction whatsoever to direct the OSP as to who or how it should go about its work. But because of Article 88, which is still in the Constitution, and every other law that contradicts the Constitution is a nullity to that extent. Okay. The framers could not have provided for Section 4 without taking into consideration subclause 4. Other than that, somebody would have gone to the Supreme Court to challenge it. Okay. That if you say that the OSP is independent...
So the law says you can't control, you can't direct the OSP.
No.
But you say, he can say, stop this investigation.
Yes.
If they do that, is that not directing and controlling?
It is, but that is the Constitution as we have it. But that is where I was going to. That if the OSP faces any such control from the Attorney General, he should put it in his report.
All right.
So that the people will judge.
Thank you so very much. Now,